So good morning everyone, I'm Dr J Gormley from the University of Glasgow School of Law. I'm delighted to see so many people here for this event, which is the first of its kind in Scotland. I'm sure it will be a fantastic day full of interesting discussions and knowledge exchange. With that being said, it's my great privilege to introduce the person who will commence this inaugural Scottish Sentencing Research Symposium, and that is the Senator and Member of the Scottish Sentencing Council, Lord Matthews. So, thank you.
Thank you. Well, good morning. I see according to the clock up there it's 6:05, so I suggest we all go home now. The first thing I imagine you're wondering is how did he get to be Lord Justice Clerk? But unfortunately, the real Lord Justice Clerk is not able to be with us. I phoned her last night, and from what I could make out, she's very sorry not to be here and tenders her apologies, but I couldn't hear everything she was saying because of all the coughing and the spluttering. I'm pretty sure that is her sentiment. She would have been here had she possibly been able to. What I thought I might do, though, is welcome you, as we just heard, to this inaugural, and I hope it is the inaugural one and the first of many, Scottish Sentencing Research Symposium, hosted by the Scottish Sentencing Council, the Sentencing Academy, and the University of Glasgow, my old alma mater. Sentencing is a complex endeavour. Even seemingly straightforward matters may raise profound questions. As the then Lord Justice Clerk Lord Carloway noted in the 2014 case of Ferguson against Her Majesty's Advocate, quoting Lord Gill's earlier comments in Gemmell against Her Majesty's Advocate from 2012, sentencing is a delicate art based on competence and expertise rather than an exact science. Those of us who practiced earlier in the bar may not recognise those words. It used to be thought that judges would simply think of a figure and the bad ones would double it and the nice ones would half it. But I hope that today's symposium will improve awareness and understanding of the delicate art of sentencing and the ways in which this can be informed by research and evidence in relation to three important areas in particular: sentencing in young people, sentencing in mental health, and community sentencing and rehabilitation. As I look around this room, I'm struck by the breadth of experience present from within and pleasingly out with Scotland. In particular, I would like to extend a warm welcome to my judicial and council colleagues from England, Wales and Northern Ireland, many of whom have already contributed to our work and we hope will again do so in future. Can I start today by giving you a brief insight into the role of the Sentencing Council of Scotland and to reflect on the importance of research in our work. The Council is an independent advisory body made up of judicial, legal and lay members with three statutory objectives. These are to promote consistency in sentencing, to assist in the development of sentencing policy, and to promote greater awareness and understanding of sentencing. A significant part of our role in promoting consistency and public awareness is, of course, to prepare sentencing guidelines for the Scottish courts. We took an early decision that our work would be evidence-based. Consequently, I've deliberately not rushed in trying to develop sentencing guidelines overnight, but have committed to taking time to properly consider the finds of research, engagement and consultation. I'm sorry for the split infinitive in there. Our initial focus was to develop a general set of guidelines on the principles and purposes of sentencing, the sentencing process and the sentencing of young people. Having put that structure in place, we turned our attention to developing guidelines on specific offences. And I'm pleased to say that the first Scottish offence guideline on statutory offences of causing death by driving was approved by the High Court last month and will come into effect on 16th January. Once in force, sentencing guidelines support and assist judicial decision making. When sentencing an offender, a court must have regard to any sentencing guidelines which are applicable in the case. A court can decide not to follow a guideline, but it must state the reasons for so doing. We are currently developing offence guidelines on rape, sexual assault, indecent image of children, domestic abuse and environmental and wildlife crime. A further general guideline on sentencing discounting is also under development. In terms of assisting policy development, the Council's role is still evolving. As an advisory body, however, we do not see ourselves as being at the forefront of developing and driving new policy, but rather as offering expertise and assistance to inform and strengthen such work. The contribution of academic work to our objectives and its importance to improved policy making in justice and public confidence more generally has been vital. Since the establishment of the Council, we have engaged extensively with sentencing bodies in other jurisdictions, some of which are represented here today, as I've said, to understand better how the issues we face in Scotland have been dealt with by others. Discussions with colleagues from England and Wales, Northern Ireland, Australia, the United States and elsewhere have been invaluable in informing our consideration of how best to shape sentencing practice, how to create guidelines which are useful to both sentencers and to the public. Closer to home, we have engaged with a wide range of interested organisations, including the judiciary, legal practitioners, victim support organisations, groups representing offenders and their families, and other third sector organisations. In addition to carrying out such research ourselves, we are also keen to work with others, including the academic community, and looking to both support and become involved in sentencing research where appropriate. Events such as this aid our role in assisting in policy development, allowing us to showcase and, where appropriate, amplify research which might inform improved policy or practice. Our final statutory objective, to promote greater awareness and understanding of sentencing, is a vitally important one. We are embarking on a period in which we hope to explore public perceptions of sentencing in detail, building on a national survey which we published in 2019. This was the first such survey of its kind in the Scottish context. It has proved invaluable by informing much of our work since then, and is a project we intend to repeat in the coming years. Research of such depth and scale does of course require a commensurate level of resources, but this is essential if the Council is to fulfil its statutory objectives. In addition to such work, we are continuing to develop our website and social media presence as a sentencing resource for the public, and look for other opportunities such as blogs and videos to make what is often seen as a complex and impenetrable subject more accessible. I'd now like to reflect on the three areas of young people, mental health and community sentencing which are the focus of this symposium. Our guideline on the sentencing of young people is a prime example of the use of research in our work. The guideline defines a young person as someone who is under 25 when convicted. We considered this threshold very carefully. Our own experience was that offending tends to subside by the mid-20s. To understand why, we commissioned a systematic review of evidence from around the world on the cognitive maturity of younger people. This found compelling evidence that brain development can continue until at least 25, and that this should be a consideration in sentencing. In light of the weight of this evidence and research that's showing that many young people who commit offences have had adverse childhood experiences and are more likely than the general population to have experienced trauma, the guideline recognises that young people may not be as culpable for their actions as older people, and states that rehabilitation should be a primary consideration when sentencing a young person. However, as the High Court stated recently in the case of Dunn against Her Majesty's Advocate, the assessment of culpability for a young person does not involve a mere discounting exercise of an arithmetical nature. The correct approach, in our opinion, is to assess the seriousness of the offence, having regard to the level of culpability and the harm. We don't just think of what the sentence would have been for an adult and then deduct something. The guideline does not affect the court's assessment of the harm caused, nor does it prevent the court from imposing whichever sentence it considers to be most appropriate, including a custodial sentence. The second theme of today is mental health. We have committed to carrying out research and engagement to support awareness raising and other activity in this area, and to help us decide whether a guideline on this subject is required. Mental health is one factor amongst many that may contribute to offending, and the interaction between mental health issues and other factors such as social deprivation, unemployment, homelessness and substance misuse is complex. There is a clear need for further research in this area, particularly to explore our evolving understanding of mental health and mental disorder and the challenges in addressing this in the context of sentencing. We look forward today to discussing these and many other issues in this important area. Our third theme of the day is community sentencing and rehabilitation. This has been one of our areas of focus over the last few years. We have carried out research with sentencers and engagement more widely, exploring the use of and confidence in community disposals. And we have targeted a significant amount of our public education efforts towards addressing the lack of public knowledge around these sentences and what they involve. To that end, we have developed a public information video on community sentences, which will be premiered, as they say, later today. I hope this has been a useful reflection on both the role of the Scottish Sentencing Council and the importance of research and engagement to our work, and how it underpins the delicate art of sentencing. I would like to extend my appreciation to the chairs and speakers at this research symposium for sharing with us today their professional knowledge and experience, and to thank you all for joining us today for what I know will be a very interesting discussion. Lots of time for discussion has been built in, so hopefully we can all forge some new connections and amplify this important work after the symposium. As has been said, we'll prepare a short report for publication following the event, and we'll take away and consider ideas raised for us and others. I would now like to introduce our first speakers, Dr Hannah Graham, Senior Lecturer in Criminology at the Scottish Centre for Crime and Justice Research at the University of Stirling and valued member of the Council, and Dr Nicole Vidal, our Principal Research Officer, who has over 10 years of experience in interdisciplinary approaches to research. I didn't say it here, but she's valued too. They will give you an overview of the research work of the Council, and there will be an opportunity to ask questions at the end of their presentations. So, thank you. Hannah?
It's wonderful to be here. This event has been a long time in the considering and in the making, and as much as I very much appreciate and enjoy the formidable tenacity of Lady Dorian's chairing, in her absence when I heard that it was Lord Matthews, I think you will get a demonstration today of not only his acuity and wit in issues of law and of empathy for people affected by harm, but you're also going to understand perhaps why he's been implicated in a BAFTA award-winning documentary, because his sense of humour is a delight to be around. The council meetings are confidential, so I can't enlighten you as to how that works, and I wouldn't dare. But can I say that I thoroughly enjoy being a member of the Scottish Sentencing Council for a number of reasons. In terms of thank yous, this will happen throughout the day, but can I very much so say thank you to Nicole, Julie, Tom, Jay, Julian and their teams for the sheer amount of emails and work that has gone into this. It's wonderful when things are achieved together. So I'm qualified as a criminologist. You might hear in my accent that my qualifications might have happened at the other side of the planet. So trained in Australia, but have lived in Scotland for several years, and about 4 years ago applied to join the Scottish Sentencing Council, feeling like perhaps the most unlikely candidate to have the role of the lay member or the academic member, and you can imagine my surprise at being appointed, but it's something that I've thoroughly enjoyed. I will be speaking in the next moments in the capacity as a council member, so this might, for those of you who know me well, this might be the most disciplined and demure you've ever seen me. But there's an importance in that because we work collectively. Okay. So I am a member of the Research Committee, and at the moment Sheriff Fleming and also Justice of the Peace Susan Filoni, fellow members. On the Scottish Sentencing Council we have members who join us from the judiciary and law, and they are usually so impressive that within minutes or months they are promoted, which affects their tenure on the council. So if you want a promotion, come and join us, because it has been spectacularly successful in a number of cases. So the committee has other people who join us. We would perhaps like to see some considerations of our statutory obligations as to how long people can stay on the council, because we'd lovely to keep that wisdom. But if Lady Dorian were here, she would say that once you're on the council, you can never leave us. So we often have advisors or people who share their advice despite no longer being a member. So that's something that the research committee draws upon, and it supports the council in research activities in a variety of ways. I'll work through some of these in a moment, but it's an approach that provides support to other working group committees. So there are a variety of other committees. For example, I'm a member of the Comms Committee and also the Sentencing Discount Guideline Committee, and members will vary by that. But the research is relevant across the piece, as well as the comms being relevant across the piece. We have an attentiveness to being evidence-based, but also to the awareness-raising function around sentencing, and that being based on factual information and not mythical or disinformation about sentencing and Scottish justice more broadly. We'll work through some of these in a moment, but some of the opportunities of what we've had to commission have varied in scale. So anything from a large-scale public attitudes survey, which we've had a component of and would like to do more of, but also being able to commission smaller-scale qualitative and mixed research methods initiatives. We commission externally in terms of external academics. Some of the authors of those reports and literature reviews are in the room, which is wonderful, as well as conducting our own in-house research, which is something that Nicole will speak more to, although there are limitations on how much we can make public. I actually brought a copy of our research framework with us. It's available on the website. Something that the Scottish Sentencing Council enjoys is a level of attention to our research and review that we did perhaps not foresee was going to happen. Some of our most avid readers are in the Scottish Parliament and the Scottish media and in the public, so it is wonderful to see that there is such an interest. But the research framework overall is something that we've discussed and worked through as a council in seeing the management and the commissioning of research with a set of objectives and principles that try and maintain a focus so that we have an overarching vision over time, and so that we're adhering to public finance and procurement rules. So it sets out our core research interests. It offers guidance for those of you who regularly contact us with an interest in conducting research on sentencing or how it might be coherent with your research agenda. It has some guidance on how we do in-house research and our commissioned research. We would like to move more towards having more open calls for research. For example, there might be some funding associated with that, and an ability for people to approach us with various interests that are relevant to the key aims and objectives of the Sentencing Council. The Council does exist in the same fiscal and budgetary conditions that everyone else does, so we will have to bear in mind making sure that we're really diligent to our core business and the things that we've been commissioned to do, as well as hopefully moving more towards being able to open up and perhaps have an open call where people could nominate topics and select research projects that would be mutually beneficial. So it structures our decision making. It informs our approach to how we might review sentencing guidelines, which is where perhaps some of the interest comes in at times. But we want to be really rigorous and thinking through the different methods, the different forms of data collection that we could use for reviewing guidelines. And we've also taken great care to be reading through what sentencing councils in our other respective jurisdictions are doing in terms of how they research and evaluate their guidelines and consider their impact. So we undertake a fairly broad range of research and engagement activities, and we encourage collaboration with researchers and academics who specialise in various aspects of the sentencing process. The engagement is often informal, coming through the Sentencing Council inbox or through seeing one another at research events at institutions across Scotland. There's also the formal processes around procurement. So we've heard briefly some of the research that we've already been able to commission. I looked up the publicly available research that we've got on the website, and we've got anything from fraud sentencing, a systematic literature review, sentencing for assault offences, offences involving indecent images of children literature review, the sentencing of offences involving domestic abuse literature review, and the methodological challenges of comparative sentencing, as well as things around mental health, sentencing, literature and young people. So we will be working through aspects of that more so today, and you will hear about it in more depth. One of the things that's really useful for engaging with academia is the diversity of perspectives and the independence of views that comes on sentencing practices and how we can learn about applying those in Scotland. We've recently held invitations to tender for work on sentencing for environment and wildlife offences, and also on exploring unwarranted disparities in sentencing in Scotland. And as I said, depending on our budget, we hope to commission more literature reviews to assist with the consideration of some upcoming guideline topics, as well as help with the awareness-raising research. I understand that we also have some ongoing research at the moment that is focused around gender-based violence, so around victim and survivor perspectives of particular sexual offences, and victim and survivor perspectives of domestic abuse, and research that's happening in that area. And we're very thankful and look forward to hearing some of the results when they're ready. Our research priorities are guided by our remit and our interests and our business plans, which we spend quite a bit of time developing. I believe that there's a sense of our forward plan available on the website for the next few years, usually in our annual reviews. Is that correct? Yeah. It won't have as much detail as we're able to consider in-house. We have to balance things around affordability and value for money, and also how it might increase understanding of sentencing in Scotland. And I'm really thankful to our public sector colleagues in the Secretariat around how they're able to be really diligent on the tendering process. I often recuse myself on certain parts on the grounds that I'm going to know everyone who's tendering, which is wonderful. But I don't wish to be involved in that for risk of conflict of interest or bias. But we get to have a lot of say on the design of the research and working collaboratively together. So these are a fairly general overview of some of our core research interests. They will then delve deeper when it comes to certain offence topics or offence areas in which we're developing guidelines. But if it relates to sentencing, we are probably interested because that's core to our remit. Some of the interests that I really love, particularly around our anniversary and others that are upcoming, is if we could do some more around public attitudes, because there are understandings in the public domains of what the public think about sentencing and punishment mythically that don't always cohere to what we find when we speak to them. And I could say public or I could say publics, as in there are different groups who will have a variety of views and a diversity of views in that area. If you haven't seen it already, I'm hoping that we will get to star some of our videos or some of our multimedia displays. Our website has been undergoing upgrades. I won't update you on the technical details of that, but it was needed to be able to hold a lot more content in more depth. And we've got a keen eye on diversity, usability and accessibility considerations, as well as trying to think around how we could share research and visually communicate research as well as the rest of our work in the public domain. So we're using LinkedIn, Twitter or X. I believe we've recently had launches on Facebook and Instagram, so if you're not following us already, or if you want to keep your Instagram activity secret, you can consider whether you wish to follow us or not, because it is a publicly available page. So considering how we can communicate some of the facts and the videos, in particular the animations around communicating about the Sentencing Young People Guideline, really a lot of thought and effort went into how can we communicate research on maturity, ageing and how young people's brains develop, and our graphic artists work with us on that to communicate it in a way that is so refreshing and vibrantly colourful. So that's just one of the various multimedia things that are available on the website. We've also done quite a bit of work actually in terms of awareness raising and use of research. So I use quite a bit of Sentencing Council resources in my teaching as an academic at a university, both undergraduate and postgraduate, but also simple things like the Jargon Buster that's available on our website. Every year I get feedback from our amazing international postgraduate students who are learning what a procurator fiscal is and how Scots have different words for everything. And they already have distinguished experience, degrees. They might have been a lawyer, a police officer, a social worker in another nation. They're coming to do postgraduate research with us. But the explanation and the myth busting and this sentence means this. I was in a workshop yesterday where we were explaining an order of lifelong restriction and how that applies and how risk and harm, and then the courts and the RMA and so on. So we were being asked questions where you can easily refer to accessible communication that we have, but as a part of that is trying to bring in particularly there's ideas that there might not be an understanding around the young people that it's all just a trend around certain perspectives that are in, and saying, well, I don't want to name some of them, but there are views around trauma or adversity that some people take quite different positions on, but the joy of being able to use Scottish Sentencing Council resources at universities, in colleges and in schools is say, we encourage an intellectual curiosity and a diversity here, so why don't we read the research and then discuss it robustly. So we've done work also with the Modern Studies Association, and that might involve communicating our guidelines and our research in a more accessible format for the next generation, who will then join us at university, hopefully, or college. Okay, I'll move quickly. So the guideline development process has 8 distinct stages, from initial consideration of a guideline topic through to the approval of the guideline and ongoing monitoring and review. Research and consultation is critical to the development of that. I don't think I can give a variety of examples, but we have also had points where the council would be quite interested in expertise and evidence on a particular thing. So the council or a committee might invite academics and others to perhaps give us a presentation. So it might not be a fully commissioned piece of research, but we recognise we would like to learn across different disciplines, be it law, forensic psychiatry, criminology, victimology, so on, social work. It's not so much about disciplines, it's about making sure that the council is informed by people who are doing cutting-edge research, and we're able to understand that. That's at the council's discretion, so it's not something that it's an open slather, but it has been very useful to be able to ask people who are experts in their field quite particular questions that we can then learn from and very much so benefit from in the guideline development process. So thank you to those who have already been able to do that. Okay, we've covered some of this. So we draw on a range of data sources, such as statistical information on current sentencing practice, including details regarding offence volumes and average custodial lengths. And I believe aspects of how we do some of this is what Nicole will speak to in a moment. One of the key examples that we wanted to draw attention to is the findings from the systematic review of cognitive maturity of young people leading to age 25 as a consideration for sentencing. This is something that has been a topic of keen interest across a variety of people. Also, during the development of the Sentencing Young People Guideline, the University of the West of Scotland was commissioned by the Council to explore the opinions of young people aged 14 to 25, including young people with convictions and some young people who had been victims of crime, towards sentencing in general and on an early draft of the guideline. And I think that speaks to a very important principle more broadly. Fairly often in criminology, in independent academia, we would be reticent making too many claims where we haven't actually asked the people that are at the very centre of what is being discussed. So the ability to not only take statistics but to listen to and learn from lived experience among various other constituent groups that we were able to hear from is very welcome. So I've touched on some of this. Our ongoing work encompasses sexual offences, domestic abuse, sentence discounting and unwarranted disparities in sentencing. We're nearing the consultation phase for work on rape and indecent images of children. And we're also, as I mentioned, trying to, where possible and where the budget allows, commission public perceptions research into victim and survivor views and experiences where we can prioritise this and it can inform our upcoming work. Okay. I should also mention we are in the stage of monitoring and reviewing the Sentencing Young People Guideline, and our 1-year review is underway. I won't say a lot extensively about this because it's about to feed into what Nicole can speak to, because she's at the forefront of working with our team to do this. But one of the unique positions of the Scottish Sentencing Council is conducting research with the judiciary in different ways that the access that we have is not taken for granted. It is very much appreciated given how incredibly time poor they are across various workloads and the pressures that are on the courts at the moment. And it's very, very useful and very, very informative to hear directly from those who are doing the sentencing. So I might... I need to be incredibly well behaved here. So what is the extent of the impact of our evidence? So we're finding increasing interest in our work as a council overall. It certainly has stimulated an interest in sentencing more broadly across the public. In a healthy democracy, the interest is welcome. We wouldn't wish to dissuade that. I've had the privilege of giving evidence to the Justice and Home Affairs Committee in the House of Lords as a member of the Scottish Sentencing Council, because they took an interest in trying to understand more about community sentencing in Scotland, in Ireland and elsewhere in the US in that panel. because they would like to understand more, and our colleagues and together as a council we submitted written evidence which I believe has been cited in public perceptions of sentencing reports released by the House of Commons Justice Committee. So we're feeding into it. We have been able to feed into policy and practice discussions at Holyrood. There are some lively and vibrant views in that area, and long may it continue. So we're quite happy to be feeding in. It feels mildly uncomfortable to try and assess the extent of our own impact because in terms of politics and Parliament there are other factors that might be in play, and we don't wish to necessarily mark our own homework, but I hope that given our statutory remit it's useful and relevant and we're able to inform debates on this. I'll hand over to Nicole, our principal researcher, and she will give you some insights on the behind-the-scenes work that we very much appreciate.
Thank you very much, Hannah and Lord Matthews. Thank you. I'm very delighted to be here today. I'm looking forward to hearing all of the presentations that we have on the agenda for today, and I'm also very excited to be able to share with you some more work about the Council, but in particular about the work that we do as the Secretariat for our in-house research, our internal work, and our work supporting the Council. I'll try not to repeat too much of what's already been said, but I'm looking forward to sharing some more of this, so that the discussions that are raised today are going to, I'm guessing and I'm anticipating them to be very worthwhile and interesting and engaging. In terms of all the other speakers that will be speaking today as well. I'll just go to, let's see the time, looking at the time, but I think we're okay. Our in-house research. So we have been hearing about the various forms of research that the Council leads on, and a part of these efforts, the Council conducts a broad range of engagement activities and research internally, our in-house research. So myself, as the Principal Research Officer, I am involved in the development of many of these activities, but I should very much emphasize that this is a team effort. It's very much a team effort. We work closely together, we collaborate, all with the aim to advance the objectives of the Council. We place a high value on evidence gathering, on data and evidence to support our work. As researchers, evidence and data and rigor and all of these things, they're like the bread and butter of what we do. So, in terms of Council business, this is especially important. To this aim, the Secretariat, we are responsible for collecting and synthesizing quantitative and qualitative data, evidence to inform the development of the sentencing guidelines, also as well as the wider body of our work, raising awareness and whatnot. We actively, as has been mentioned, we actively solicit perspectives of experts in their respective field. We engage in consultations on the guidelines, impact assessments, and we maintain a continual process of monitoring and review. So what is the criteria for in-house research versus commissioning externally? For a project to be considered for our in-house work, we need to ensure, of course, that it's properly aligned with Council objectives, with the aims of the Council. All of our significant in-house research projects will generally be granted approval by the Research Committee or by the Council itself. So the criteria to achieve this, there are a set of criteria that we hope to obtain, and that's if we have the necessary skills within the team, already present within the team, or if we can acquire them, either the skills or with people with human resources. And if we can do this within the project timeline, then this would make it appropriate to handle the work in-house. We should also, of course, look to see if the skills that we have, that we are acquiring, will be useful for future Council business. And also that the time that we commit to these projects, we want to give them the proper time to gather this evidence, this rigor, but we need to make sure that this doesn't disrupt the functions of the council. So we've been emphasizing today evidence-based research, and as I'm saying, it's the bread and butter of what we do as researchers. But the reason for this is that it does inform each stage of guideline development, so and also our work overall. But in addition to the commissioned research, the work that we do in-house, this helps us to tease out some of the key issues, some of the priorities, challenges, barriers, and facilitators, all of this that we do in order to, the initial exploratory work that we do, seeking views of judges, consulting on guidelines, monitoring and review. These are things that we really want to find out, what are the issues that are arising. So our approach ensures taking into account the perspectives and experiences of the sentencers. I'll speak a little bit more about this in just a bit, but this guarantees that the guidelines are informed by real-world scenarios and current practices. Statistical evidence. So we do draw on a range of quantitative data, which the Council utilizes for a number of purposes. This includes comprising the evidence informing sentencing guidelines, as well as the production of impact assessments for those guidelines. The impact assessments are also available on our website, which we encourage you to look through our pages for our publications as well. So the Scottish Courts and Tribunals Service, SCTS, provides us with data as a statutory obligation. This is under the Criminal Justice and Licensing Scotland Act 2010. This data set, we can request this upon request. They include disposals for specified charge codes of interest, which also contain some personally identifiable data set variables. We also draw on the Scottish Government's annual publication, Criminal Proceedings. The annual Criminal Proceedings publication is a very thorough, detailed document, data set, but it's not always sufficient for the work that we carry out. The Criminal Proceedings data set, the work that we do, it requires us to have an understanding of all occasions on which particular offences are charged, but the Criminal Proceedings data set includes only data where the relevant offence is the main charge. So we do prioritize that data set given how thorough it is, but we definitely use the SCTS data set in parallel, complementary to each other. Another important element of what we do is helping to develop suggested sentencing ranges. In order to formulate these, it's not just statistics, it's necessary to take into consideration various factors. We look at it holistically. We look at the range of appropriate sentences set out in any relevant sentencing guidelines, any relevant guideline judgments, binding case law, relevant legislation, including maximum and minimum sentence, powers of the court, and any statutory presumptions relating to sentencing. So formulating sentencing ranges does require drawing from a range of sources. It also includes some of the work that we do in-house, research conducted with the judiciary through interviews and surveys, also the statistical data, analysis of cases and appeals, members' personal experiences, and public consultation as well. I just want to note that these sources, we cannot look at them in isolation from other influencing factors or content within the guidelines. It's very much an iterative process. We look at it holistically. We see where ongoing engagement and testing assist in refining these findings in relation to the rest of the guidelines. I should also say that we currently have only one such guideline, and therefore, as with all of our research, as it should be, we are very conscious to approach this very carefully. We definitely want to avoid any negative unintentional impacts. The interviews with the judiciary, I find this a very interesting part because this is where we can actually get into the detail. I'm a qualitative researcher by trade, but this is where we can get into the detail of what what the issues are, the barriers, the facilitators, and really probe and find out, staying on topic, but really probe and find out what sorts of things are driving some of the issues that arise. So the interviews with the judiciary are aimed to provide us with a better understanding of judicial opinions relating to challenges in sentencing, and they're intended to inform the development of sentencing guidelines and our greater body of work as well. The interviews are qualitative. We use a semi-structured topic guide for these, but of course we have room to probe and discuss some of the things that arise organically. We do aim to obtain equal representation from all sheriffdoms, depending, of course, on the priority of the topic in question. The interviews seek judicial reflections on sentencers' own experiences and thoughts on what influences the sentencing process, on challenges specific to sentencing offenses. So we ask things related to determinants of seriousness, of harm, of culpability. We ask about, some of these things might be self-evident, but we ask about sources of information and evidence necessary for sentencing, as well as any other factors relating to the accused, to the complainer, to the offense. Really anything that comes up within the conversation, then we try to probe on that. The judicial surveys. So we also conduct judicial surveys. As a survey is, these are mainly quantitative, but we do have some open-ended questions in these. So they're complementary to the interviews and all the work that we do. But the surveys are aimed to elicit sentencers' personal experiences as well. And the purpose also is to enhance our understanding of judicial decision-making in the topic of interest, to identify any facilitators or challenges. The surveys prioritize the values of mutual trust, of privacy, confidentiality. It's worth noting also that the surveys are, there's exclusive access for these. It's reserved solely for the judiciary. These are generally conducted just prior to the public consultation stage of guideline development. And in the past, we have conducted surveys on principles and purposes of sentencing, the sentencing process, on sentencing death by driving, sentencing young people, and also ongoing consultations for current guidelines in development. As part of our work, we also work on impact assessments and M&R. So as part of the guideline process, the development of the guidelines, the Council is required to produce an impact assessment for any guideline that it submits to the High Court for approval. So this must include an assessment of the costs and benefits which implementation of the guideline is likely to give rise to, an assessment of the likely effect of the guideline to the criminal justice system, and all of the work that we carry out in relation to determining the content of the guidelines also goes towards assessing potential impacts. In terms of M&R, the Scottish Sentencing Council has a statutory duty from time to time to review any sentencing guidelines published by it. So to fulfill this duty, the Council has committed to undertaking reviews of offence and offender-specific guidelines at the 1-year stage and the 3-year stage after the guidelines have been enforced. So this methodology, it's not new. It was developed a year ago, and it was agreed a year ago, and this is available to view on the website, which again, I encourage you to take a look at our pages. There's some contact details there. I've given a bit of an overview of the in-house work that we do, and together with my colleagues here, with Hannah, with Lord Matthews, I hope that we've been able to share, an overview of the work of the Council and how we support the Council. I just want to reiterate, we've discussed this a lot this morning already, but just that the value and emphasis that we place on our commitment to ensuring that all aspects of the Council's work are underpinned by evidence, by rigor, by expert knowledge, that this is driving, this is informing all of the work that we do and the work in supporting the Council. I'm looking forward to the rest of the day and the conversations that will ensue. Thank you very much.